Last time on the Darrell Brooks show.
You have got to stop. It's fine if you object. I will rule on it as I deem appropriate under the rules of evidence, which, by the way, I provided a copy for you. See that big book over there?
No,
it has the criminal statutes. It has the traffic code. It has the rules of evidence. Well, it's on your table. It's behind the microphone, and it's there. I've provided it to you as a courtesy so that you have that available to you. Right, I'm directing the bailiffs to remove him to the other courtroom. I've provided ample opportunity for Mr. Brooks to abide by the simple rules of decorum and civility.
Your Honor, I don't consent or agree to what you are doing.
Your lack of consent is noted for the record.
I don't give consent to an estoppel.
I'll make a more full record when we are open again to the public.
I don't give consent to be removed.
Madam Reporter, the record should reflect the court is stepping off the bench. You may step off.
I move for a motion to dismiss. You still haven't even ruled on the claim. There's no one that even has a claim against me here.
Before we continue, the record should reflect that, and at the moment Mr. Brooks is muted, so I can appropriately make my record here today. I will promise to unmute him when we continue with the hearing after I make my record regarding the removal, assuming he can maintain even the simplest of civility and not interrupt other individuals in a way that is disruptive and disrespectful.
The camera pans to the empty seat where Mr. Brooks used to sit, a reminder of the strange antics that unfolded mere moments ago. We then see Mr. Brooks in the other courtroom, dejectedly trying to figure out how to use headphones.
Prior to the court ordering Mr. Brooks removed from this courtroom, there were 9 interruptions. So it was on the 10th that this court ordered him to be removed to appear remotely from that other courtroom. I have cited repeatedly from Illinois versus Allen, which is it is an elementary standard of proper conduct to not interrupt. Mr. Brooks repeatedly interrupts.
Mr. Brooks is shown holding a sign reading objection. He cannot object as usual because his mic is muted.
I gave him 9 warnings before I removed him to the other courtroom. As the court did in Allen, this court, with that, I will turn back to Attorney Opper. I am going to unmute Mr. Brooks, but also advise him that if he interrupts Attorney Opper or others as they are providing testimony here today, I understand he can object. However, if he can't do any of that, he will remain muted, and the process will then be, we've given him a sign. He's holding it up right now, demonstrating for us. He has the objection sign. He will be required to write down his objections on a piece of paper that will be provided to the bailiff. The bailiff will provide it to me, and then I can rule on those, even if it's striking testimony later on. I do expect his objections to be based in law. All right, go ahead, Attorney Opper. For the record, the mute has been undone.
Before we continue with the episode, let's review why Ms. Wallenhoff is being questioned. In the previous episode, The COVID Gambit, Mr. Brooks submitted an inmate communication form, also known as an ICF, that said he wanted to delay the trial because he was put on a COVID protocol.
We're talking about health and we're talking about safety.
Now, court doesn't work like a job. You can't just call in sick. There has to be a legitimate reason why the trial should be delayed. Mr. Brooks was clearly not too sick to stand trial, as we see him answering questions and even standing up.
I don't know if you're standing or sitting on the chair. I can't quite tell. It appears like you're standing, but maybe leaning over the table. Oh.
He tried to claim that he wasn't allowed to leave his cell.
Till then, I am on a protocol which restricts me to my cell.
But there he was, outside of his cell. He tried to claim that he thought he was contagious, but Darow pointed out that he was 6 feet away from everyone else. Being rather charitable, the court brought up the point that perhaps being on the COVID protocol would restrict his ability to prepare a defense. Luckily, Ms Wallenhoff, the jail supervisor, was there to answer questions about the COVID protocol.
So I'll have you sworn in. I'll just do it. Raise your right hand. Do you solemnly swear that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you. Would you please state your first and last names for the record?
Angela Wallenhoff.
Thank you. So, Ms. Wallenhoff, I was asking you, correct?
Correct, ma'am.
And that, correct?
Correct, ma'am.
And that is correct?
Correct, ma'am.
And nothing
Hold on
about...
a second. Mr. Brooks, the basis for your objection at this time?
That is irrelevant to why I'm asking for adjournment. I was not asking for adjournment based on being able to utilize the conference room or a tablet.
Your objection is noted. It's overruled. Her answers may stand. Next, you may continue, Attorney Opper, with your next question.
The, nothing about this, correct, ma'am?
Objection.
Overruled.
Correct, ma'am.
And he,
Objection.
Overruled.
Yes, ma'am.
and there would be nothing,
Objection.
Overruled.
Mr. Brooks becomes visually agitated at the repeated denials of his objections.
Correct, ma'am.
and when he, is that correct?
Objection.
Overruled.
Correct, ma'am.
And in fact,
Objection.
Overruled.
That is correct, ma'am.
sure. Mr. Brooks had told this court earlier that he reported that to them.
Objection.
Overruled.
I have not reviewed the jail medical record.
Okay, I guess maybe I'm asking a question I don't know the answer to. If he were to say to one of the officers or a lieutenant,
Hold on a second. Was that an objection or just a comment under your breath?
In response, he merely raises his objection sign.
Your objection's noted. It's overruled.
Of course.
if he were to complain of illness to
They would give him,
your knowledge, was that done by Mr. Brooks?
not to my knowledge.
And are you aware of the fact that last weekend, on or about Saturday, he requested a shower and a shave?
Yes.
Was that provided to him?
Yes.
If he weren't.
It would depend what type of a protocol.
Okay, thank you.
Those were all my questions. Thank you, Ms. Wallenhoff.
Mr. Brooks, do you have any follow-up questions for Ms. Wallenhoff?
I do. You stated that it would depend on what type of protocol I was on, would dictate if I'm able to shower, correct?
That was not completely what I stated.
Well, that's what you just stated on the record.
Well, different management protocols, it would be in accordance with jail operations, and my preference, Judge, would not to be to speak to all of the jail operations.
Right, I'm not going to require her to speak to all the jail operations. If you wanted to ask her, for example, whether your current protocol would prohibit that, I think that would be a fair question.
So that would be the question then. Let me ask this. What specific protocols would prohibit being able to shower?
Objection, irrelevant.
I'm not going to, it's sustained. Mr. Brooks, I'm going to honor the request of the jail administrator not to talk generally about protocols given the operations of the jail, but you may ask her if there's something specific as to you.
Well, because of my situation being a little bit unique, would any protocol that I am on currently prohibit me from being able to shower and or shave?
Do you speak moving forward?
As of right now,
You would be allowed to shower on the protocol you're currently on.
would I be able to shave?
You would be able to shave.
Would that be with the clippers or a razor?
Objection, relevance.
Overruled, she may answer.
Mr. Brooks, we would monitor behavior and other factors in that and make a determination.
So, to your knowledge, are you aware that we are only permitted, and I'm saying myself as well, being housed in the jail, that we are only permitted razors once a week and clippers only once a month?
Judge, I would prefer not to answer questions in regards to jail operations.
Right. I'll honor the request of the jail administrator. It goes beyond the scope of this hearing. She need not answer general questions about the general procedures and protocols within the Waukesha County Jail. We're a little far field. I gave you a little bit of leeway, but we had started this off about COVID protocols and your current situation. So from my perspective, the questions regarding the discovery materials and all of that were relevant because you claimed you weren't being allowed out to a conference room. That to me implicated your ability to prepare for your defense and this trial. So that's why I allowed those questions. Whether you shower or shave would, in my humble opinion, not be relevant to the issue of whether you can assist in your own defense.
Well, respectfully, Your Honor, that was brought up by the prosecutor. It was brought up about the whole issue of being able, me requesting to be able to shower and shave, so that's why I brought it up in my question.
I understand, and I'm under my authority, under 906.11, I'm going to advise both parties that anything regarding those types of things are not relevant, and I won't allow questions from either side regarding that any further, at least today on this particular issue.
Thank you, Your Honor. I would want to make one correction for the record. I never claimed not to be able to have access to certain things. I merely claimed that I am on a protocol which limits me even more than I'm already limited. I made no reference to anything in specific, just the fact that I'm on a protocol which restricts me to my cell until the test can come back.
I appreciate that clarification, sir. Thank you. Do you have any other questions for Ms. Wallenhoff?
Yeah, a couple more.
Okay, go ahead.
Would you care to share with the court on record the types of protocols that I am currently on outside of the COVID protocol?
Objection, irrelevance, goes to jail operations.
Sustained.
Does my specific protocol change the normal time that I would be allowed out of my cell?
Judge, again, that speaks to jail operations.
Mr. Brooks, unless you have a specific question related to access to your materials, I'm going to have her not answer that as it goes to.
Well, that directly goes to that because as we know, I'm only on a protocol where I'm only allowed out of my cell a few hours a day as it is. Now being restricted to my cell because of the COVID protocol, the question I'm asking is, does that restrict even the time that I can be able to be out to utilize the things that I need? Because essentially, I'm already limited.
Can I ask?
There's times.
I want to make sure I follow you, Mr. Brooks, so I'm sorry for the interruption. If I hear what you're saying correctly, you may have a belief that your access to certain things that would impact your ability to prepare for this case is impacted by the COVID protocols. Is that a fair assessment of what you're trying to convey?
I would say that would be accurate in a sense.
And so if we ask the jail administrator that specifically, is there anything about the COVID protocol that would interfere with your ability to have access to materials or a room? Is that a question you would want answered?
That would be fair, Your Honor.
All right, do you understand what he's trying to ask?
So what I'm understanding is, obviously, Mr. Brooks is allowed to keep legal material in his cell.
Right.
So I do not believe the protocol limits his access to legal material.
Thank you. Do you have any other questions?
Yes, I do. As far as she just referenced the telephone. To the best of your knowledge, are you aware that there is a certain times that the phone will be available? You have other inmates that...
Let's not talk about other inmates, but are again, I'm sorry for the interruption, but I want to try to get us through these questions. If you're asking...
Okay, let me ask it another way.
Okay, go ahead.
Being that because of this COVID protocol, I won't have my usual time out of my cell that I would have regularly, would I be able to utilize the phone in the same manner that I would be able to use the phone had I not been placed on this protocol? Or would it be strictly by me having to just ask?
I guess I'm unclear as to the manner you speak of. What are you referring to?
I think I was very clear with it.
Are you trying to ask her?
Are you aware, which I know you are, that the protocol that I'm on outside of the COVID protocol prohibits me from being able to utilize the phone at certain times of the day. Would the COVID protocol prohibit that any further?
Mr. Brooks, are you trying to ask whether the COVID protocol impacts your phone privileges?
That's what I just said. No, not in a sense, because I think it's more accurate with the way that I asked it.
But your question assumes facts not in evidence and that are beyond the scope of this proceeding. I'm concerned about what, if any, impact the COVID protocol has on your ability to prepare for this case. So I'm going to limit your questioning in that way.
Well, can we at least make a clarification on the record that the reason why we're having this didn't have anything to do with limiting my preparation?
So
that wasn't the real issue.
I think it's related to the.
I just wanted that clarification.
I understand.
That's all.
I understand what you're saying. I respectfully disagree. That's why I've allowed some of the questioning. I believe it's relevant to the motion that's before me from you.
Well, I didn't agree to that, but the reason why I brought it up was because I've been on the outside of the COVID protocol. The protocol that I've been on for a very, very long time. So my phone use is limited to certain hours of the day, which works out.
All right, Mr. Brooks, we're getting a little far field. I need to make a determination on your request, so I'll ask you one last.
You haven't let me finish what I was getting to.
Mr. Brooks, I will ask you one last time. Do you have any other questions for the jail administrator? Because right now you're talking more about things you would provide. So if you have a question that's relevant, please ask it.
I didn't say anything I would provide. Where did I say that?
When you provide information through just a statement about things, that's not evidence, right? The witness on the stand is providing us testimony. Testimony is evidence. Not that I wouldn't accept certain statements from you, but also understanding the state has the ability to challenge those by asking questions of the jail administrator or other individuals so that I can make a determination today on your motion. With that, Mr. Brooks, do you have any other questions for the jail administrator?
Well, everything you just said still speaks to not understanding that I have, Your Honor.
Mr. Brooks, one last time, do you have any additional questions for the jail administrator?
Your Honor, what you're doing right now is you're not being fair right now.
All right, Mr. Brooks has not answered. Mr. Brooks, I need to make a ruling right now. Please stop. He's not answered my repeated question as to whether he has any additional questions for the jail administrator. Unless there's any further questioning from the state based upon the additional questions that were asked, then I'm going to have her step down.
I just want to ask of the court if you're intending to take up his inmate communication form that was dated September 28, 2022 as well, while Ms. Wallenhoff is on the stand. I just have a few questions related to that, Your Honor.
I object to that. Relevancy. What does it have to do with what she's testifying to right now today? They're two separate issues. Objection for relevancy.
Hold on, Mr. Brooks.
As a sign of protest, he again raises his objection sign, despite being unmuted.
I am going to allow the jail administrator to be questioned regarding document 258. I don't know if Mr. Brooks has a copy of that in front of him or not, so I will print it off in that courtroom so that he has that.
So that I have this correct on the record, you're making a judicial determination to allow testimony of something that has no relevancy to what's being raised today. How do these are two separate issues?
The court recognizes that they're two separate issues, but I also have, it promotes judicial economy, and that's my decision. So go ahead.
Can I put Your Honor on notice that I intend to appeal that decision?
Your statements noted of record. All right, go ahead, Attorney Opper.
Ms. Wallenhoff, I don't believe you have the document in front of you, but
can someone confirm whether that document was given to Mr. Brooks as well? I did print it to the printer over there. I have that ability. It was. All right, thank you. The record to reflect he has also been provided with a copy of docket number 258.
I'm not acknowledging that document, Your Honor. I'm not acknowledging that. I don't consent to any.
All right, I'm going to mute him because he's interrupting. Mr. Brooks, it's a document you filed, and it's a document that was filed through the inmate communication form process. So go ahead.
Thank you. Ms. Wallenhoff, you've seen a copy of this document previous to today, correct?
Yes, ma'am.
And you're aware that to the court, Mr. Brooks indicates that he is on a, quote, keep separate, end quote, in the jail, correct?
Correct.
And at the conclusion of the form, near the bottom, the last two sentences, he indicates that he has no access to the materials he needs to prepare for trial because of the keep separate order, correct?
Correct. That's what he states.
Okay. Is that a truthful statement? Well, let me ask a different. That's a bad question. I strike that question. Did Mr. Brooks have access to his legal materials during the time that he was under a keep separate order?
Yes, ma'am.
Thank you. I don't have any other questions on this topic, Your Honor.
All right, Mr. Brooks, I will unmute you. Do you have any questions on this topic for the jail administrator?
Yes, I do. Just stated on record that I had access to all materials for trial prep during the time of this keep separate, correct?
It doesn't specifically say what you don't have access to, so yes, what was in your cell.
Did you just say in open court on the record that I in fact had access at the time of this keep separate?
2 items in your cell, and you could have access to the conference room to view electronic legal materials.
So am I correct in saying that when you brought over these discovery materials to the pod, that I was in fact in one of those conference rooms and I talked to you face to face? Is that correct?
You were in a conference room and we spoke.
And I informed you then that I was on the keep separate, correct?
I do not recall that.
I specifically told you that I was on a keep separate with the guy that was in the cell next to me that had placed that on me, correct?
I do not recall that.
So you don't recall, you can recall that we spoke, but you can't recall what we spoke about.
I informed you at that time I was delivering the banker's boxes.
And I took the liberty to explain to you that I was on the keep separate and that was going to hinder me being able to prepare. Is that correct?
I do not recall that.
You don't recall that, or you don't remember me bringing it up?
I do not recall us having a conversation regarding the keep separates. We had a conversation regarding me delivering your legal material.
So, is there a way to verify when the keep separate went into effect?
Objection, relevance.
Well, hold on. Mr. Brooks, as I read this inmate communication form, and perhaps it's just a simple question, when you wrote it, did you have access to the banker's box of materials yet?
No, I did not. Ms. Wallenhoff just testified the last time that she gave testimony that she brought the discovery materials over on Thursday the 29th. She did say that in open court on the record.
Yeah, she said that previously.
This inmate request was written on September the 28th. At that time, I was already on the keep separate protocol, which does not allow me to come out of my cell.
But is the issue the keep separate protocol, or that you didn't have access to the materials that we've now established through testimony you had access to once they were delivered to you?
The keep separate protocol in itself, Your Honor, restricts the 2 people that have the keep separate from being able to come out of their cell until one of them is moved. Whether that be to another unit in the pod or a different pod, that part I can't speak to, but neither of the parties are able to come out of their cell until someone is moved. The reason why initially why I wrote it was because that stops me from being able to shower in the unit, because officers will have to then take me to another part of the jail, sometimes in the pod, in a secure shower is what they call it, which is downstairs.
Sir, I'm just going to stop you because I honestly, the whether you have a shower or not is not relevant to the issue of whether you had access to the materials you need to prepare for your case. So I read this inmate communication form, especially that very last sentence. I am respectfully asking and requesting that my trial be slightly delayed as I have no access to the materials needed to prepare for trial. Thank you. So my question to you is, and I think you've already answered it, but I want to make sure. At the time you wrote this inmate communication form, the materials had not yet been delivered to you. Is that your testimony?
The boxes that were brought over had not yet been delivered. I had already had maybe 10% of the discovery materials that was provided to me by my former attorneys on this matter.
Right.
That in itself was very, very voluminous in itself.
Sir, we had a prior hearing related to the access provided to you and when the materials were provided. You may recall that Attorney Perry even testified over Zoom audio about that. The jail administrator testified as well. To me, that record is very clear that the materials that were provided by your defense attorneys following their discharge on your case were received by you on September 29th of 2022. That has been established. No one is disputing that. So that's the record that I have before me. I understand what you're saying about the keep separate, but also at that hearing, it was made very clear to everyone that the jail administrator gave some specific directives as it relates to you and access to certain things.
I do recall that, Your Honor. And one of the questions, if you recall, one of the questions I had about what you just said was, did all the officers know about that specific order? I guess it would be called. I don't know what it was exactly, but the information that was to be passed down from Ms Wallenhoff to the officers.
Right, and I'm not going to revisit that because you were given ample opportunity when we first addressed that to ask questions and to provide other information, meaning statements from yourself. And the clear record from that is that the information was put into the jail management system. It was documented, and that the jail administrator had no information to suggest her employees did not have that information and honor that information. There was no testimony from anyone else to suggest that that wasn't followed. So
I would like to say something for the record, Your Honor, on that.
Go ahead.
To speak to what you just said on that, it's possible that all officers were not aware of that. I even talked about this with an officer who worked just last night that wasn't even aware. And his answer was that he had been off for a few days, so to his knowledge, he wasn't aware of that. And that issue came up because I specifically asked to utilize a tablet. So in my mind, that would say to me that I'm not trying to argue if the order went out to the officers. That's not what I'm disputing. I'm just disputing the fact that every officer that works in my pod is aware of that.
All right, thank you. Any questions at this point for the jail administrator? Again, not related to the shower, but related to access to materials.
Does a keep separate protocol, Ms. Wallenhoff, does a keep separate protocol restrict inmate movement in any way?
Objection, relevance.
Sustained. Overly broad. Next question, or rephrase.
Does being on a keep separate protocol, or rather, should I refer to myself? If I am on a keep separate protocol, would that, in effect, limit me to only being in my cell and being able to only utilize what I would essentially have in my cell?
That's a compound question, so you have to break it down one at a time. So, rephrase.
Would a keep separate protocol restrict me to cell confinement until arrangements can be made for me to be able to resume my normal activities?
Judge, I would prefer not to answer that. It's due to jail operations. We would look at each individual in each situation. I think it's overly broad.
Mr. Brooks, I'm going to honor the request of the jail administrator to not answer that because it would require her to provide information regarding jail operations. It's overly broad. You need to limit the question to how this protocol limits you, specifically as it relates to access to materials needed to prepare for trial. Not generally whether you're on any kind of restriction, whether, but the focus is how this impacts your ability, if at all, to access materials needed to prepare for trial. Other than we've established that you didn't have the materials from your attorneys that were provided after they were discharged by the court until September 29th. I mean, we've established there was a gap, right? I granted the motion and allowed you to represent yourself on the 28th. That was a Wednesday. And then the materials, even though they were turned over to the jail, it sounded like in the evening on the 28th, there was protocols in place to go through that, and then those were provided to you on the 29th. That is well established on the record. So I understand that. We've addressed that in part previously, so I know the state wants me to address this, and I think I know the reason why, but if there's any question you want to ask the jail administrator about what was going on the 28th or 29th, or even going forward, that would impact your ability to have access to these materials, that's the type of questions you need to ask, okay?
Well, I asked the question and I was told that it wouldn't be answered. I asked at the time that she brought over the discovery materials, was she aware that I was going to keep separate protocol at that time?
Asked and answered.
Sustained. The answer was already provided. She doesn't need to answer it again. Next question.
What was the answer to that?
The record speaks for itself, sir. Next question, please.
I don't recall her answering that specific question.
Next question, please.
Brooks scowls at Judge Darow.
Can you provide for me where she answered that specific question?
Mr. Brooks, do you have another question for the jail administrator?
Is it going to be answered? Is it going to be honored?
The record speaks for itself, sir.
Well, if the record speaks for itself, then that question should be able to be answered. Were you aware, Ms Wallenhoff, that at that time I was on a keep separate protocol? That it was already in the system that I was on that protocol?
What date are you referring to, sir?
The date that you brought over the discovery materials. Were you aware at that time, on that date, that I was under a keep separate protocol?
You previously asked me if I recall the discussion you were informing me.
But that's not the question now, though.
I was aware.
The question is the day that you brought over the discovery material. Were you aware at that time that I was on a keep separate protocol?
I can't state for certain at that moment in time. I was aware you were on a keep separate. I can't state what date that I was made aware of that. I think it was due to a complaint that you sent forward to the jail.
I sent no such complaint. The complaint was by the other party. Were you aware of that?
Judge, I prefer not to answer this. I don't understand how it impacts what he has
Mr.
had
Brooks,
access
we're
to.
far afield from the issue at hand, so I'm going to ask you one last time, do you have any additional questions for the jail administrator?
What are you allowed and not allowed to do on the keep separate protocol?
Objection, relevance.
Sustained. All right, then. I gave him the opportunity to ask questions. That was his last one.
I wasn't done.
Mr. Brooks, I'll give you one more opportunity then. They need to be relevant. They need to be within the bounds that I've already discussed.
That was in the bounds. I just asked this.
The issue is limited to the impact of the keep separate on your ability to have access to materials needed to prepare for trial.
But Your Honor, with all respect, every question that I asked that had relevancy to that was either overruled or she was directed not to answer that.
Mr. Brooks.
So
Mr. Brooks, you indicated you had other questions. I will give you this opportunity if you can ask a question that falls within the scope that I've previously identified. Do you have another question?
Would I be allowed out of my cell on a keep separate protocol?
It's vague, Your Honor. The question is, was he allowed out of his cell to access his legal materials?
That's not what I asked.
Right, the question you asked, the objection is sustained. If you'd like to ask the question suggested by Attorney Opper, that would be permissible by the court.
No, I would want to ask my own question. Thank you. Was I able to come out of my cell on the keep separate protocol?
Judge, I would prefer not to answer that.
It's beyond the scope of the inquiry right now. The jail administrator need not answer that question.
Can you give me the basis why, Your Honor?
It's beyond the scope.
What does that mean? I do not understand.
Judge Darow looks like she is approaching the very end of her sanity.
Mr. Brooks, do you have any other questions?
I do not understand what beyond the scope means. That was a direct
One last time,
question.
sir. Do you have any other questions?
That was a direct question.
All right, I'm going to mute him because he's now not being responsive to the question that I asked, and that is, does he have any questions to ask the jail administrator within the scope that I've previously outlined?
We see Mr. Brooks angrily talking to the monitor despite being muted.
Any follow-up from the state?
No.
All right, thank you. You may step down.
The camera pans back to Mr. Brooks, where we see that he is still angrily gesticulating.